I mean, is there even a Merit Systems Protection Board anymore? Right? Didn't Trump fire? I don't even know if they have a quorum.
Yeah, they may not. But I mean, that's not how these cases proceed.
Welcome to Law and Chaos, where the Justice Department is borked beyond belief. Luckily, America's trial judges are not borked, although the appeals courts are still TBD. Let's talk Perkins Coie, Voice of America, and the conservative chop shop that's suing Chief Justice John Roberts. We've got a lot to cover, so let's get after it. Hey guys, I'm Liz Dye, and with me as always is Andrew Torres. Andrew, how are you?
Well, I just got word as we went to record that lunatic president of ours wants to reopen Alcatraz, which has been a national park since 1963, to serve as a prison again, I guess, and that he's going to tariff foreign movies because they are, his words not mine, a threat to national security. So Liz, I hope you got something good for me today.
I do. Let's start with Maine Governor Janet Mills.
A few months ago, I stood in the White House, and when confronted by the President of the United States, I told him I'd see him in court. Well, I did see him in court, and we won. I am so pleased to say that Aaron Fry's able representation of the state of Maine has resulted in a binding agreement by the U.S. Department of Agriculture, Brooke Rollins and all of her staff, whereby they agree to refrain from freezing, terminating, or otherwise interfering with the state of Maine's access to USDA funds allocated to any official or agency or department of the state of Maine based on alleged violations of Title IX. This resulted from a USDA letter on April 2nd from Brooke Rollins, which I have described earlier to people as something that smacked of a ransom note written by a school child. A demand letter that was outrageous at the time, remains outrageous today. We immediately filed suit 5 days later, filing a complaint and a motion for temporary restraining order. And 4 days after that, federal judge John Woodcock, a seasoned, decades-long serving federal judge in Maine, issued a 70-page opinion, a decision that issued a temporary restraining order against the United States Department of Agriculture based on his conclusion that the state's likelihood of success is extraordinarily high, one of his many conclusions in that decision.
Okay, well, let it not be said that you do not deliver, ma'am.
Yeah, I love her. I love her. Yeah. And just to be clear, the incident arose because in February, the governors were at a lunch at the White House, and President Trump singled Mills out, Governor Mills, the governor of Maine, and said, you've got to stop letting trans girls play sports. And she said, we're going to follow the law. And he said, I am the law. And she said, we'll see you in court. And she did, and she got a TRO, and obviously she won.
Yes, and the government entered into a settlement that, again, you just heard Governor Mills describe as total victory. So we haven't seen the terms of it, but she's happy, I'm happy, and the girls in the state of Maine are happy. So that's what matters.
Absolutely. And just before we leave this, the Trump administration's claim is really a truly bizarre one. Their claim is that it violates Title IX to allow trans girls to play sports because it takes away, in some fashion, from girls in sports, cisgender girls playing sports. That's not an interpretation that has been embraced by any court in the land. I don't have any confidence that the U.S. Supreme Court is going to protect the right of trans children to play sports. But I know that the law is not what the Trump administration is saying that it is. And I think part of the reason that they kind of backed off here is that they are loath to test this proposition. What they prefer to do is bully states into getting rid of, trans athletes, supports for trans athletes, and hope not to have to put this fakakta legal theory about Title IX to the test.
Yeah, with this administration, you punch back and they fold.
Love it. Okay, well, that was delightful. But now we're going to talk about the broken Justice Department because the DOJ is rapidly turning into a banana republic enforcement vehicle for the president. So continuing with our theme of laws mean the opposite of what they say, the Civil Rights Division will now be shifting its focus away from prosecuting race and gender discrimination cases and toward cracking down on so-called DEI and the schools who allow trans athletes to play, which again, as we said, no court has ever said that that violates Title IX. The Civil Rights Division will also be concentrating on, quote, combating anti-Semitism. And as an actual Jew, can I say thanks, but no thanks, since combating anti-Semitism is now code for deporting people who support Palestinians and criminalizing First Amendment protected speech?
Yeah, you knew it was going to be bad when the Senate confirmed Trump's whack-ass lawyer, Harmeet Dillon, to head the Civil Rights Division. She is a loon who filed a bunch of anti-trans and vote suppression cases in private practice. I think her firm was mixed up in a bunch of Trump's troll suits as well. Like I'm pretty sure the lawyer on that from her shop was David Warrington.
Oh, he's the current White House counsel.
Oh, God.
Come back, Patsy Baloney.
Oh, my God. Okay, so after Dillon was confirmed and the Trump administration announced that civil rights was going to be the opposite of civil rights, about 2/3 of the lawyers there left, right? They were at 380 lawyers, give or take, and now they're down to 140. But Harmeet says that's just fine. She told Glenn Beck, quote, "We don't want people in the federal government who feel like it's their pet project to go persecute police departments based on statistical evidence or persecute people praying outside abortion facilities instead of doing violence. The job here is to enforce the federal civil rights laws, not woke ideology." And yes, that is a Department of Justice chief using persecute instead of prosecute. I cannot tell if she is honestly that stupid or if it's like, those young earthers who call it evolution, right? Get it?
Yeah, porque no los dos?
Indeed. So anyway, that's why the department is trying to back out of all of the consent decrees, ensuring that police departments don't violate people's civil rights. Ditto for election law cases where states try to suppress the vote because voters, quote, deserve secure elections, not fabricated claims of false voter suppression meant to divide us.
Yeah, it's the people demanding their civil rights that are divisive, not the people who are trying to take away their voting rights. And in keeping with this, the Justice Department is losing more experienced prosecutors, this time from the U.S. Attorney's Office in the Central District of California, where 3 experienced prosecutors, including the chief of the Public Corruption and Civil Rights Section, resigned after their boss blew up the conviction of an L.A. sheriff's deputy who was found guilty by a jury of deprivation of rights under color of law after he tackled a woman and pepper sprayed her for daring to film him. So the jury found the deputy, Trevor Kirk, guilty of a felony that could have resulted in a decade in jail. But the Justice Department decided it would be better to let him plead to a misdemeanor for which they recommend just 1 year of probation and no bar on becoming a cop again.
Well, that would be divisive. So look,
yeah.
I am not a criminal lawyer, but this is extremely weird, right? So one of the things that's it's a subject of some high-level academic debate in the world that we live in which 95 to 99% of criminal defendants plea bargain rather than go to trial, is what's sometimes called the trial penalty, right? And that's the idea that prosecutors are incentivized to charge the maximum in every single case to every criminal defendant so that they have more room to bargain downward, right? It's like the restaurant that triples the price of a bottle of wine and then has half off Tuesdays.
Oh, I think you're playing my walk-on music now.
Indeed. So anyway, the point is that the way it works is that if you don't plead out as a defendant and you make the government go to trial, you wind up with a worse sentence, right? The fact that the new U.S. attorney in this district, Bilal Isaili, got sworn in on April 2nd and immediately worked to blow up this case is pretty scandalous, although unsurprising, I guess, since this guy Kirk has become something of a hero in right-wing media circles. Also, what's weird is that the plea deal is signed by Isaili and Robert Keenan, a prosecutor who entered his appearance just 1 day beforehand, and no one else. So I guess it remains to be seen if Judge Stephen Wilson will go for it. He already denied the request by the Justice Department to delay sentencing so that the new U.S. attorney could, quote, get up to speed on the case. So it seems like maybe he knows that there's something up here.
Yeah, I Googled this guy, the judge. He was put on the bench by Ronald Reagan in 1985. That's the same year as Judge Royce Lamberth, who we're going to talk about in the VOA case. It would not shock me to see Judge Wilson do what Judge Dale Ho did in New York with the Eric Adams case. I mean, look, This is a totally different set of circumstances, right? Kirk was already found guilty. So Wilson doesn't really have to accept this kind of post facto rancid plea agreement. He already rejected the motion to throw out the verdict. I mean, look, I don't know what's going to happen. He could get loud here, even if he accepted it, in a way that so many of these old judges have been doing.
Yeah, I never in my life thought that I would be thankful for Reagan appointees, but here we are.
Yeah, if we have listeners who practice in the Central District of California and have the skinny on this judge, hit us up. You know, you can DM us, or you can email us. You'll find us. But while we're here in the Central District of California, let's talk about Judge Otis Wright, who is a George W. Bush appointee who is super unimpressed with the government's behavior in the case of Alexander Smirnoff.
Oh, you have been all over this story, Liz. So let me try and bring everyone else up to speed. Smirnoff is the FBI informant who tried to frame Hunter and Joe Biden for taking bribes. He fed his handler some nonsense story, which the handler immediately recognized as bullshit and disregarded. But when the Trump administration was trying to find anything to smear Joe Biden with in the lead up to the 2020 election, they went back and tried to make Smirnoff's obvious lies into a thing. And then, in 2022, Republicans in Congress went back to the well again and tried to make it a thing. Not just about Joe Biden, but now about how the FBI was in the tank for Ice Cream Joe. At which point, Special Counsel David Weiss, the guy whom Bill Barr tasked with investigating Hunter Biden, actually charged Smirnoff with making false statements to the FBI and then tax crimes because, like you always say, Liz, once the government starts looking into you, they don't stop.
Right. So Smirnoff got crosswise with Judge Wright from the jump by lying about assets and his Israeli passport, both of which would have made it real easy for him to flee. So the judges denied about 5 motions by Smirnoff to get out of jail, pre-plea and post-plea. And the Ninth Circuit backed him up on all of those. So Judge Otis Wright is not here for any more shenanigans.
Well, I'm sorry to tell you, Judge Wright, there are about to be so many shenanigans.
Yes, there are. So first of all, Smirnoff pled guilty in December and got sentenced to 6 years. But now he and the government, which you will note is a different government from the one in December, he and the government are working in tandem to modify the protective order over the evidence that's, governing it so that Smirnoff can share the information he learned there with the executive branch.
Yeah, that just reeks to high heaven. I mean, basically, you have somebody who tried to sell a false story about the Bidens and pled guilty, and now the government is like, no, let's let him tell us more lies so that we can continue to pretend that it was really the previous guy who was corrupt. Look, I know the adjective Orwellian is tossed around a lot in our circles, but Donald Trump is right now selling a meme coin that companies and foreign countries are buying up so that they don't even bother pretending it's something other than a bribe, right? Like, he is literally advertising White House tours as a prize for his highest crypto investors.
Right. Well, wait for it, because the Justice Department would now like to blow up Smirnoff's guilty plea too, or at least spring him from jail. So April 10th, Smirnoff and Bilal Asaili, remember he's the U.S. attorney here, filed a joint stipulation asking for release pending appeal because, quote, the United States intends to review the government's theory of the case underlying defendant's criminal conviction. By the way, he pled, right? This is a guy who entered into a plea deal. It's not the government's theory of the case when the guy pled guilty. Okay.
Yeah, just like Michael Flynn.
Hold on. He's coming. So Smirnoff also files a supplement suggesting that Judge Wright botched the sentencing calculation, and so his plea is actually invalid. You may imagine that this did not go over well with the judge, who was literally a federal prosecutor in California since 1980, which is the year Smirnoff was born. So last week, Judge Wright rejected the agreement, the stipulation to let Smirnoff out pending appeal. He basically said there were no new facts and Smirnoff was still real squirrely and he still represented a flight risk. But he said this, and you'll tell me what you think, Andrew. He says, the United States offered that Smirnoff is, quote, at the lowest incentive that he would ever have to flee the country when he has a receptive ear to people who are willing to look anew at his case, seemingly referencing the United States' decision to review Smirnoff's case. However, the United States has not yet decided the outcome of this review, and the fact remains that Smirnoff has been convicted and sentenced to 72 months in prison, providing ample incentive to flee.
Yeah, I mean, reading between the lines, that sounds a lot like the Eric Adams case to me, right?
Me too.
Here's a guy who has something that the Trump administration wants, and the government is maneuvering to put him in a position where his liberty is now dependent on giving it to them. And, the judge who, as you pointed out, has been around the block a few times, smells something fishy.
Yeah, I mean, I think there's no way to look at this other than as a totally corrupt payoff for somebody who tried to do a solid for Donald Trump, who tried to help Trump get elected in 2020. I mean, the guy pled. Yeah. And this isn't even, look, this is sort of different from Michael Flynn. We all remember, or I assume we all remember the first time around when the Trump administration blew up the Michael Flynn, he had already pled guilty. They blew it up before the sentencing. This isn't that. This is after the sentencing. Right?
It's worse. Yeah, that's a good point. Yeah.
Right. I mean, I don't think the judge has to take this. The judge doesn't have to let him out. I mean,
I don't either.
Right?
I think what you do is what happened with Flynn, right? Like you maneuver the administration into the position where you say, look, if you want this guy out, pardon him. Right?
Yeah. And I mean, here's the thing. If they don't have to pardon him, if they can spring him while he's, while they're saying we're thinking about your case, then they have leverage over him to get him to do what they want. It's exactly the same as Eric Adams, only it's worse because Eric Adams hadn't been tried yet. This guy pled and got sentenced.
Yeah, agreed.
Okay, we have so much more batshit corruption to talk about, but it is Tuesday, so let's take a moment to thank our new supporters over on Substack. Thank you to Elisa Haas, Max McGee, Rich, Zach, CTM, My Dear Deadly, Marcy C, Notes for Me, Aaron Gavenda, and Krista Allen.
And on Patreon at patreon.com/lawandchaospod, thank you to Hito Guy, Dr. JKL, Leonard Untung, John Duckworth, Nachtwind, Megan Richmond, and Janus Ostrichars. And I'm really sorry if I botched your name, Janus. And if you'd like to join their ranks, you know how to do that. Just head on over patreon.com/lawandchaospod or hit us up on Substack at lawandchaospod.com, and you will get all of the bonuses, the extended episodes, and you will not have to sit through any ad breaks, unlike everybody else who is going to have a brief one right now, and then we will see you on the other side.
And we are back. So, in keeping with our theme of prosecutors acting as a political arm of the White House, it has been widely reported that the government will be settling with the family of Ashley Babbitt, the woman who was shot by Capitol Police as she tried to break into the Speaker's lobby adjacent to the House chambers during the January 6th Capitol riots. Her husband filed a $30 million wrongful death suit against the government in January of 2024. He is represented in this case by Judicial Watch.
Yeah, let's put an end to anyone saying that Judicial Watch is a nonpartisan government watchdog. I mean,
looking at
this
you, Cal.
case is, you know who you are, buddy. This case is offensive garbage.
It really, really is. Just all kinds of slanderous allegations about the poor Capitol Police. And nothing has appeared on the docket yet, but it does appear that this thing is a done deal. We just have to wait to find out how much of your tax dollars they handed over to make this thing go away. To an insurrectionist. Right. But actually, this gives us a minute to talk about something that you and I and our buddy Cal McClanahan have been talking about for a long time, Andrew, and that is the tort suits by Trump and his dipshit buddies against the federal government. Like, what's going to happen now that Trump's henchmen are in charge of the till?
Yeah, so specifically last summer, one of Trump's personal lawyers, this doofus named Daniel Epstein, said Trump was going to sue the government for the illegal raid at Mar-a-Lago, which, was a lawfully executed search warrant. And you and I had a good laugh on the air because that is so multiply wrong on so many levels that, you hardly know where to begin. Like, the Federal Tort Claims Act does not waive the government's sovereign immunity for suits for malicious prosecution or tortious getting a judicially approved search warrant or whatever else Epstein is claiming. Nor does the FTCA allow a complainant to recover punitive damages. And Epstein said he was going to, get $15 million in compensatory damages for, I don't know, moving the boxes out of the pool shed, and then $85 million in punies, which, are not allowed by law. And also, Epstein based his claims on violations of the Justice Department manual, which explicitly, says there right in bold type, cannot be used to support a private right of action. So, on those 9 things, heck of a job there, Epi.
Right. So under the Federal Tort Claims Act, you have to present your claims to the government, and they have 6 months to say yes or no, which brings us to the obvious issue here, because if Trump is paying out cash to Ashley Babbitt's family, why wouldn't he pay himself?
I mean, I don't know. He's making so much money from his other scams.
Yeah, I mean, at this point, maybe it's chump change or whatever.
Yeah.
But why wouldn't he authorize the government to pay Mike Flynn, like we said? Because that loon is suing the government in Florida for malicious prosecution and abusive process under the Federal Tort Claims Act, which, as we said, that's not a thing. That case was dismissed in December, but he had a right to amend the complaint. And now he's gotten 90 additional days to amend, during which he's supposedly going to review all the information Trump declassified about the Crossfire Hurricane investigation. That was the investigation into the 2016 election. So he's pretty sure that's going to totally prove that he did not lie to the FBI and the whole thing was malicious prosecution. So please give him $50 million from the public fisc.
I mean, I wish the listeners could hear the eye rolling, but look, Liz, I'm really glad that we're covering these stories, because this is what I expected from the second Trump administration, right? A kleptocracy where they stole everything that wasn't nailed down and then got out the crowbars for everything left, right? And just because Trump is also dismantling democracy as we know it, does not make this a story that is, less illegal and less appalling. And so I'm glad we're talking about it.
Yeah, there is so much going on that we didn't see coming, right? Nobody saw Doge coming. I did not anticipate that Trump was literally going to burn down the entire government. But you're right, we did anticipate levels of corruption. And because everything is on fire and he's more or less taking a sledgehammer to civil society, all of the normal corruption that we saw coming, we don't even have time. I remember during covering the first Trump administration, at this point, I was covering all of these emoluments clause cases because we said it was, a total violation of the emoluments clause for Trump to run that hotel in D.C. And now, foreign governments don't even have to show up at a hotel. They can just buy
they
meme
just
coins.
Wire him money directly, right?
Right. I mean, his sons are doing all of these deals. They're not even pretending not to be corrupt. And because we're trying to protect what's left of democracy, we don't have as much time for those claims. But that doesn't mean that it's any less scandalous.
Yeah.
Okay, so speaking of Daniel Epstein, the goober lawyer, he has filed a truly batshit lawsuit on behalf of the America First Legal Foundation, which is Stephen Miller's whack-ass litigation shop.
Is Stephen Miller actually a lawyer?
No, he is not.
Well, this isn't actually a lawsuit, so I guess that tracks.
Yeah. So this case was flagged by Josh Kovensky, a reporter from Talking Points Memo, and props to him, because I certainly wasn't looking for this one. But let's start out with the case caption, because it is America First Legal Foundation versus John G. Roberts.
As in Chief Justice of the U.S. Supreme Court, John G. Roberts.
One and the same, sir. This is a FOIA suit against the Supreme Court.
Okay, well, let me stop you there, because you can't FOIA a federal court. That's not a thing.
Oh, look, maybe you can't FOIA a federal court, but that's because you don't have a MAGA bigly brain like these guys. I mean, to be fair, they're not exactly FOIAing the court. They're FOIAing the judicial conference. But let me see if I can parse this logic. Hold on, I just got to take a big sniff of this Sharpie marker and then snort a line of paint chips.
Don't bogart the good paint chips. Okay?
Yeah, my house is quite old. We got some paint chips around here. Okay, step one. Quote, for several years, the media and enterprising lawmakers have launched an onslaught to destroy the impartiality and political neutrality of Article III courts, and particularly the Supreme Court. Step 2, this is not a quote, it's a light paraphrase. After everyone found out about Justice Chalmers' sugar daddy, the Judicial Conference, which is sort of a standards-making body for the federal judiciary, clarified its disclosure policy to confirm that judges can't just call fancy trips hospitality and not mention them. And that policy change was then recorded in the Federal Register.
Well, since you were paraphrasing there, like that part is true. So go on.
Okay, step 3, underpants gnomes.
Yes, so many gnomes.
And step 4, the Judicial Conference and the Administrative Office of the Courts are executive branch agencies subject to FOIA.
What?
Yeah, look, I'm telling it to you like I read it. They're saying that the Conference and Court Administrative Office is engaging in congressional accommodation and oversight, which is the province of the executive branch. Ipso facto, the Judicial Conference is now under control of the president and subject to FOIA.
Good luck with that, fellas. I mean, I should be careful what I say, because this case did get assigned to Judge Trevor McFadden, possibly the Trumpiest judge on the bench in the U.S. District Court in the District of Columbia. But still, like that is not comprehensible. And I guess this is as good a time as any to say that the emergency appellate panel that we keep telling you is going to get better at the D.C. Circuit for May, it maybe got worse.
I mean, I don't know that it got worse because, like, Judge Henderson. So you guys know this is the emergency panel. So it's 3 judges who are going to hear all of the emergency appeals. And since the Trump administration takes appeals of all kinds of things which are not appealable, they're getting a workout, right? And so for the past 2 months, we've had, like, as you say, there are 4 conservative judges on the D.C. Circuit: Naomi Rao, Gregory Katsas, Justin Walker, and Karen LaCraft Henderson. And damn if 2 of them haven't been in every 3-judge panel for the past 3 months. And so we thought, okay, it's going to be better in May. It is not better in May. Who is it in May now? I can't even remember.
Yeah, it's Walker, Henderson, and Millett.
Jesus. Like, Millett she's great. I think she's an Obama appointee.
Yeah, but you know,
what are you going to do?
Writing a lot of dissents,
right? So I think we're going to see, spoiler alert, we're going to see some en banc action. But we're going to talk about that in a minute. We're going to take a brief ad break here, unless you are a subscriber, in which case you will not be taking an ad break. Not now, not ever. And we're back, and it's time for a visit with our favorite Beryl, Judge Beryl Howell, who is mad as hell, and she's not going to take it anymore.
Girl, same.
So she begins, no American president has ever before issued executive orders like the one at issue in this lawsuit, targeting a prominent law firm with adverse actions to be executed by all executive branch agencies. But in purpose and effect, this action draws from the playbook as old as Shakespeare, who penned the phrase, the first thing we do, let's kill all the lawyers.
From which you may infer that Perkins Coie got its permanent injunction of the executive order targeting it. This is such an interesting opinion on so many valences, right? We're obviously here for judges taking the Trump administration to the woodshed, but there were so many fascinating dissections of the law. Like, let's just take one because it was so smart. It has to do with the claim that the government is justified in punishing Perkins Coie because of DEI.
The woke.
Exactly. But look, all they really have is a minority fellowship, which was discontinued in 2023, and statements on the firm's website that, the firm supports diversity, including by using the Mansfield rule for candidate interviews. Now, the Mansfield rule is named after Arabella Mansfield, the first woman lawyer in the United States. It's actually inspired by the NFL, which has the Rooney rule that says teams have to interview at least one minority candidate for head coach vacancies, right? So the Mansfield rule says that firms should strive to interview at least 30% minority or disabled applicants for each job. And Perkins Coie had a statement on its website that said they support that. That's more or less the whole basis for the claim that the firm practices what the Trump administration calls discriminatory hiring. Now, that really presents 2 separate issues, right? One, is the Mansfield rule illegally discriminatory? And 2, does Perkins Coie saying they support the Mansfield rule prove that they do in fact discriminate. So, you and I can find lots of different ways to answer those questions. No, but here's what Judge Howell said with respect to the first issue. She said, though conceding the use of the Mansfield rule for interviews isn't so problematic, government counsel suggested the problem lies in the way the program measures their success by showing percentage increases of qualified underrepresented talent in certain positions, which the government assumes means that the imposition of targets and evaluating people on race, sex, and ethnic-based issues unrelated to them as individuals.
Right. So the Trump administration says this all the time, and I don't think I understood, mostly because I hadn't looked into it, what they say all of these firms use quota systems. And I think what they're pointing to is firms say, we support the Mansfield rule. That is not a quota system at all.
No.
That says we're going to try and interview. Well, you'll go ahead. Let Beryl explain it.
Yeah. Oh, but you're exactly right. Anyway, Judge Howell continues. This assumption about the metrics reported, however, presupposes that the qualified underrepresented talent considered are given a positive preference when other explanations are just as plausible for percentage increases of such talent. The principle underlying such programs as the Mansfield rule is that negative biases against qualified underrepresented lawyers due to their race, sex, gender identity, disability, or ethnicity reduce their likelihood of being selected as frequently to interview for positions for which they're qualified. But when firms consider more underrepresented talent on their own individual merit and not disadvantaged for the traits unrelated to them as individuals, firms tend to hire more of these individuals on their own merit. In other words, the metrics might mean exactly the opposite of what the government assumes to be true, and exactly what the government says it wants. The government's mere assertions, just like the government's possibly erroneous assumptions about the Mansfield rule, provide no evidence of any illegal or discriminatory practice by plaintiff.
Right. So look, she didn't call out the implicit assumption of the government's claim, which is that minority applicants are inherently and always less qualified. So if they get a job, it's because of DEI. And note that while lawyers like Harmeet Dillon, who is unbelievably heading up the Civil Rights Division, they're talking about targeting law firms for discriminatory hiring, the Civil Rights Division has not jumped up to file any of those lawsuits, right? Because like their fakakta interpretation of Title IX, I think they're not itching to subject it to legal scrutiny because I don't think they're confident that they're going to win.
Yeah, although possibly there's just no one in the office.
But, yeah, well, that's true too.
On the second issue, Judge Howell said this. The government's briefing reveals the true motivation lurking behind the facade of discrimination allegations, the administration's disapproval of plaintiffs' speech in favor of diversity. For instance, the government points to the firm's statements about efforts to contribute to the advancement of our historically underrepresented attorneys and success in hiring new partners who are women or attorneys of color. Once again, however, the government provides no evidence to suggest that any of these statements show any suspect or illegal actions by the plaintiff. Public statements supporting diversity, standing alone, as they do here, provide not even a scintilla of evidence of impropriety, let alone illegality. A fair reading of the record and taking the government at its word requires finding that the justification stemming from plaintiffs' purported racial discrimination was motivated only by plaintiffs' First Amendment protected speech in support of diversity.
Right. What she's saying is if the only evidence that you have that the firm Perkins Coie is discriminatory in its hiring is statements on his website, that's not evidence. That's speech. And you can't, prosecute them or take away a government benefit just based on speech. And that's another reason that the government would rather bully than sue because this is not evidence that's going to hold up in court. I mean, it might be part of evidence, but it's certainly not going to be concluding, right? They would have to prove that there was discrimination in hiring rather than just, platitudes on the website about wanting to achieve better balance and hire more historically disadvantaged lawyers. Okay. I would note also that the Mansfield rule appears later in this opinion on the section on equal protection, because even if the Mansfield rule were illegal DEI, 360 law firms have pledged to follow it. So unless the government is going to hit every one of those firms, they are violating the 14th Amendment and Fifth Amendments because they're treating similarly situated people differently or similarly situated law firms. The order also violates Perkins Coie's client's Fifth and Sixth Amendment right to counsel. And of course, it violates the First Amendment in all the ways, right? Obviously, you can't punish people or law firms for suing the government, which is the main justification here, right? That the order says over and over that Perkins Coie, sued on election cases, represented Hillary Clinton, represented the DNC, and that all of that is core First Amendment speech, and it violates due process to arbitrarily kneecap the firm in retaliation for it.
Yeah, I agree. That was all fascinating. I was very interested to read Judge Howell's analysis of the part of the executive order dealing with the security clearances, because the government has claimed that security clearances are non-justiciable, cannot be reviewed by the courts because they lie within the president's absolute executive purview under Article 2. And Judge Howell said this was more like the government's prior ban on issuing security clearances to homosexuals, right? Like, if the president announced that security clearances for all pregnant women were to be rescinded, you could clearly challenge that in court. Here, the order purported to yank security clearances from everyone who works at Perkins Coie. Secretaries, mailroom clerks, partners, all of them. She says that's more like banning pregnant women than individualized determinations that can't be challenged. So TLDR, she shit-canned the whole executive order.
Yeah, and she also had some choice words for the Vichy law firms that caved and cut deals with the White House. She said some clients may harbor reservations about the implications of such deals for the vigorous and zealous representation to which they are entitled from ethically responsible counsel, cough, cough, since at least the publicized deal terms appear only to forestall rather than eliminate the threat of being targeted in an executive order. Okay, so what she's saying here is, you guys, if you piss Trump off, the Vichy law firms, you can get hit again. So he's still got power over you, and you can't claim to be adverse to the government when he's got power over you. Okay, continuing. Right. Only when lawyers make the choice to challenge rather than back down when confronted with government action, raising non-trivial constitutional issues, can a case be brought to a court for judicial review of the legal merits, as was done in this case by Plaintiff Perkins Coie, LLP, Plaintiffs' Counsel Williams and Conley, and the lawyers' firms, organizations, and individuals who submitted amicus briefs in this case. If the founding history of this country is any guide, those who stood up in court to vindicate constitutional rights and by so doing serve to promote the rule of law will be the models lauded when this period of American history is written.
I mean, I don't have anything to add to that other than, hear.
Yeah, I mean, I have a little bit to add. I mean, we talked the other day about Microsoft switching out its attorneys from Simpson, Thacher, and Bartlett, which is one of the Vichy law firms that signed, that gave Trump whatever it is that he's asking for, and hiring attorneys from Jenner and Block. And I think that this is she's saying history is going to remember these Vichy law firms badly, and she's all but saying you have disgraced the profession and you have betrayed your own ethics, and that's not nothing.
Yeah, I don't think this is going to get reversed on appeal, right? Not even at the Supreme Court, not even going to draw an angry dissent from Clarence Thomas.
Yeah, I think that's right. I think this was such a gross breach on so many axes. It violates both a lawyer's understanding of their jobs, and it violates so many constitutional amendments. Like there's just no way that this is going to survive. And of course, there are the 3 other pending lawsuits. I do think that I think that the firms that caved are going to live to regret it.
I agree.
Okay, we're going to take a quick ad break, and we will be right back.
And we're back. Okay, so let's talk about the U.S. Agency for Global Media cases. USAGM administers the Voice of America, Radio Free Europe, Radio Liberty, Radio Free Asia, the Middle East Broadcasting Networks, and the Open Technology Fund. And Trump has tried to shut those down because he's the enemy of all good things. And he has tasked Arizona also-ran Kari Lake with making it happen.
Yeah, I mean, I think he also hates fair and accurate media, which supports democracy, because, he does not support democracy. So, there could be a whole bunch of reasons.
Yeah, extremely fair. Anyway, these cases are important because obviously these are vital organs of American soft power, which Donald Trump does not understand, but also because they are likely to become a major showdown in the impoundment cases. And we're going to unpack that, right? So specifically, these are not federal grants like the National Institutes of Health funding, right? These agencies were created by Congress, and they have statutory mandates to stay on the air. They are funded by a line item in the budget. If Congress's power of the purse means anything at all, the president cannot unilaterally defund these agencies and shut down their broadcasting network.
Right, which is exactly what Kari Lake tried to do, or is trying to do. After taking over, she sent a boilerplate email to 1,042 of the 1,147 full-time employees at USAGM, placing them all on administrative leave. And the next day, she canceled all USAGM personal service contracts. She fired 600 contractors, and then she instructed the foreign news services to shut down their transmitters and place locally employed staff on leave. And she planned to fire every radio broadcast technician working for it anywhere in the world. And as a result, Voice of America stopped reporting the news for the first time in the whole 80 years of its existence, and its affiliates either went dark or switched to pre-recorded music.
Yeah, and to be clear, federal law, it is 22 U.S.C. section 6202C1. It requires the Voice of America to, quote, serve as a consistently reliable and authoritative source of news. So this is yet another example of the Trump administration just flat out breaking the law. And I think they know they're not going to win on the merits of this decision, right? So what they're trying to do is Humpty Dumpty everything, right? So that by the time a court tells them to fix things, there will be nothing left to fix.
Yeah, we wrote about this for yesterday's blog post at longcastpod.com. But
nice
but the administration's latest Humpty Dumpty strategy involves a jurisdictional statute called the Tucker Act of 1887.
Yeah, that is 28 U.S.C. section 1491A1. That applies to any claim for a breach of any express or implied contract with the United States or for liquidated or unliquidated damages in cases not sounding in tort.
Yeah, so that's a law that's meant to help government contractors get paid. So if you, say, have a paving company and you get hired to repair a section of I-95 and then the government refuses to pay you what you're owed, the Tucker Act is the mechanism to resolve that claim and get you paid, right? And the way that you get paid is because Congress created this special court called the Court of Federal Claims exclusively to hear those kinds of breach of contract cases. And clearly you can see that the government refusing to pay grantees or depriving states of education funds or just burning down whole federal agencies and funded by Congress is not the same as somebody who gets hired to do something and is owed money by the federal government. It's the difference between the budget and, some subcontractor.
Yeah, that's exactly right. And to understand kind of the depths of this disanalogy, we need to take a quick rabbit trail, but only back to episode 39 when we were talking about the Alex Jones bankruptcy. And in that episode, you and I, Liz, talked about the difference between Article 1 and Article 3 courts. And that naming convention comes from the Constitution. Its structure. Article 1 sets out the powers of Congress. Article 2, the powers of the president. And Article 3, the powers of the judiciary. So the kinds of federal court judges we talk about every day, right? District court, circuit court, and Supreme Court justices are all under the rubric of Article 3 judges, right? And they are a separate and co-equal branch of government. But Congress has also created, think of them as helper courts, right? Like bankruptcy courts. They're called Article 1 courts because they are not part of the judiciary. They are not a co-equal branch of government. So, for example, judges who serve on Article 1 courts aren't appointed for life, right? Like bankruptcy court judges are appointed to 14-year terms. And importantly, the Court of Federal Claims is an Article 1 court. So those judges are akin to bankruptcy judges. They are not like Article 3 federal judges. Federal Article 3 judges, right, even though they sit in a court of limited jurisdiction, they have general equitable powers, right? So that means that a judge, a federal judge, an Article 3 judge, can issue injunctions, can impose sanctions, can award other kinds of relief, even if there isn't a specific law that authorizes it, because they have that power. But Article 1 courts can't do that. They can't do any of those things. They can't rule on anything or issue any kind of relief that Congress did not specifically authorize them to do.
Right. So what that means is that if the government can successfully funnel all of the challenges to its illegal impoundment of funds into the Court of Federal Claims through the Tucker Act, those judges will not be able to impose any injunctive relief, right? They can't make USAGM rehire anyone or stop them from doing mass layoffs or like selling the building or the transmitters or whatever terrible shit Carrie Lake thinks she's going to do. And worse, the Court of Federal Claims has 16 active judges, 10 of whom were appointed by Donald Trump in his first term. And, look, if you're wondering what kind of nominees they are, Trump nominated that goon Daniel Epstein we talked about, who is suing, Chief Justice Roberts. He nominated that guy to the CFC in his first term. I mean, thank goodness the Senate just ignored it. But this is inherently a much more conservative bench. It's much more likely to be friendly to this administration than the trial bench in D.C. or Maryland or Massachusetts or California, wherever these cases are going to be brought.
Yeah, and the Court of Federal Claims is already over capacity, right? Adding thousands or tens of thousands of new cases to its docket will crash that court, right? Which, if you're the Trump administration, I that's what you want, right? Like, they want a huge backload of overloaded judges who are limited in the kinds of relief that they can award.
Yeah, I mean, it's functionally no relief if you have to wait years and years, right? So there are a bunch of parallel cases challenging Carrie Lake's decision to try and feed USAGM into the wood chipper. And those cases are all in front of Judge Royce Lamberth in D.C.
He is a Reagan appointee and has long been one of the most conservative members of that court. We've written about him a bunch because he's surprised us in Trump's second term.
Right. And this is one example where he surprised us because he issued a series of temporary restraining orders requiring the administration to stop mass terminations, restore people to their jobs, immediately disperse the $12 million allocated by Congress to USAGM for April. And he also rejected this Tucker Act argument completely. We should note the government has been making these Tucker Act claims in all of these impoundment cases. And as happens so often lately when the Trump administration is about to come into open conflict with a trial judge, the Supreme Court races in at the last second and seizes on some random bullshit, which they stick in a 2-page order on the shadow docket. But because they're the Supreme Court, they're like BS note jotted on a cocktail napkin in the middle of the night has the force of actual law. So in a case called Department of Education versus California, they ruled that the lower court order that the government had to disperse teacher training funds to the states should be stayed because of the Tucker Act. Which was not something that any court had entertained, even though the government kept saying it. So the Supreme Court's 5 justices said that the state's claim was more like a contract claim against the government under the Tucker Act than an Administrative Procedure Act claim, which, you just have to prove arbitrary and capricious government action. That was 5-4 with Chief Justice Roberts siding with the liberals. But the government took this, I think it's 4 paragraphs, and they were like, cool, all impoundment cases are Tucker Act cases now. Thank you, howler monkeys. But Judge Lamberth wasn't buying it. He was like, what even is this Tucker Act shit? Like, the USAGM plaintiffs are not making a contract claim. They have statutory rights under the International Broadcast Act and the budget, which is, by the way, a law. So he issued TROs ordering USAGM to give the broadcast agencies their money and rehire everyone they'd laid off.
Which is great, but then those TROs were immediately stayed by the aforementioned terrible panel of the month at the D.C. Circuit. That was Judges Katsas, Rao, and Pillard. And I cannot stress highly enough how bad, how contrived, how results-driven this ruling from Judges Gregory Katsas and Naomi Rao was. That's Obama appointee Cornelia Pillard in dissent, obviously. But this decision had 2 components, right? The first were the mass firings, right? Liz, as you pointed out, the USAGM placed over 1,000 of its 1,100 employees on administrative leave immediately, fired a whole bunch of contractors, and Katsas and Rao held that all of those claims need to be funneled to the Merit Systems Protection Board as individual employment disputes with the federal government.
I mean, is there even a Merit Systems Protection Board anymore? Right? Didn't Trump fire? I don't even know if they have a quorum.
Yeah, they may not, but I mean that's not how these cases proceed, right? The second component is the Tucker Act claim, right? And here, Katsas and Rao were picking up what the government was putting down, right? They held that Congress, quote, created a contractual scheme for allocating funds to the USAGM, and by contractual scheme, they meant that because USAGM promised to pay the funds allocated by Congress by law, and the various networks in turn promised to use the funds to broadcast the news, again, as they are required to do by law, those become, quote, exchanges of promises reflecting offer, acceptance, consideration, mutuality of intent, and action by an official with authority to bind the government. They constitute government contracts for Tucker Act purposes.
Oh, so every time the government promises to do something as a contract, the Court of Federal Claims is about to become like more busy than the rest of the district courts. But okay, go on.
Yeah, no, obviously that is not the law. And this panel of the D.C. Circuit just didn't mention at all the Supreme Court case on this issue that literally controls and that they are obligated to follow. It is a 1988 decision called Bowen versus Massachusetts. And in that case, the Commonwealth of Massachusetts challenged a decision by the Reagan administration to disallow certain Medicaid reimbursement expenses, right? So obviously, in one sense, the state was suing to get the funds that it was owed. But the Supreme Court held that just because the state would get money if it won, that didn't make it a contract claim for purposes of the Tucker Act, right? And in particular, that case belonged in an Article III court, right? Not in the Court of Federal Claims, because the state was not just seeking reimbursement, but also challenging the agency's determination that could recur in the future. So if that agency determination was left unadjudicated as what would happen if this proceeded as a Tucker Act claim, then it would represent, quote, an ongoing policy that has significant prospective effect and affects far more than any money past due. Right? So the clear rule at the Supreme Court since at least 1988 has been, if you ask for declaratory relief and injunctive relief, those are, and again, Supreme Court's words here, certainly not actions for money damages. Like, it's harder to get more clear than that, except Katsas and Rao have just ignored that decision, which, seems a little weird for an intermediate appellate court, but hey.
I mean, to be fair, the Supreme Court kind of suggested that when they put out that order in Department of Education v. California. But yeah, this whole thing is confusing to me. I mean, we have this whole line of impoundment cases. The most well one is Train versus City of New York, where Richard Nixon didn't want to disperse, I think it was like environmental remediation funds. And the Supreme Court said, you have to give that money to the state of New York because Congress said so. And you know what? That wasn't a Tucker Act case. It was not in the Court of Federal Claims. Like, there are impoundment cases. I mean, Scalia ruled in a bunch of them, so they're not like in, long ago memory. Right. There couldn't be any of those impoundment cases if every claim against the executive branch to force it to pay money was supposed to be a Tucker Act claim. That just can't be right.
Yeah.
Okay. So the plaintiffs today moved for reconsideration en banc of the Katsas-Rao state order. That means they're asking all 11 judges on the D.C. Circuit to weigh in together, not just this randomly selected and terrible 3-judge panel. And we're going to talk about it more in the subscriber bonus. But just to be clear, you have all of this weird shit going on at once. Like, there are rules for civil procedure, and they are that you cannot appeal a TRO, a temporary restraining order, much less an administrative stay. The government has appealed TROs over and over and over. And you've seen that. And it's also weird and disfavored to ask for an en banc review. But I think we're going to see a lot of that too. And we've sort of tacitly agreed that the rules of civil procedure are not entirely what they used to be pre-Trump.
Yeah, I think that's right.
Okay, we're going to talk about this petition for en banc review because it is actually pretty interesting in the subscriber bonus. And if you are not a subscriber bonus, we will see you on the other side of our last ad break. And we're back. Okay, I think I'd like to have a bit of a discussion maybe with you, Andrew, about what we're looking at here, because you and I have talked about there being sort of 3 buckets of things. And a lot of it comes from Project 2025, but there's sort of three super illegal things that the Trump administration wants, right? One, they want to get rid of impoundment. So that's like the whole thing of Project 2025, which is to seize control from the legislative branch of the budget and use taxpayer dollars to leverage them to force the states and force every other entity, Harvard or, the state of Maine to like kick trans kids off of sports teams, or to leverage all kinds of social change that they can't get through Congress, right? They can't get these laws passed. That's one of the main priorities that's set out in Project 2025, to get rid of the Impoundment Control Act. The second are these sort of staffing cases, right, or federal hiring cases. What they want to do is reshape the federal bureaucracy by being able to fire all of the career employees and all of the agency heads. And they've had a lot of success in that. But the case that they want to get rid of is, well, there are two of them. They want to get rid of all of the, bureaucratic civil service protections, and they want to get rid of this case called Humphrey's Executor. Right. Which is the longstanding precedent that says that there are certain kind of executive branch agency heads who can't be fired, but Trump has gone ahead and fired them.
Can't be fired at will, but can be fired for cause, right? It's the protections are not that strong, and they want to demolish even those minimal protections.
100%. And then there are these kind of due process cases, because one of the things that the Trump administration is their greatest priority is deporting people, and we've seen them, carry that out in ways which are totally extra legal. And I mean, you and I have talked about how there's such a parallel between the way that this Impoundment Act case is going down and the way that the deportation cases went down, which is that the Trump administration wanted to do something that it couldn't legally do, and it kind of went ahead and dared the judiciary to stop them. And when it clearly it was going to come to a head in the JGG case, which we've talked about a lot, when they defied Judge Boasberg's order to turn the planes around, and they said, they threw up two middle fingers, the Supreme Court kind of leapt in and said, "Oh no, you can't you can't challenge these deportations under the Administrative Procedures Act. They have to be, let's call them habeas claims." And the effect of calling them habeas claims was to kind of disperse them so that there couldn't be a collective action, that there had to be, smaller actions, and they were in basically any venue where the government could control the venue by locking the deportees or the potential deportees, detaining them in places in Texas where they thought that they were going to get a good hearing from trial judges, and certainly from the Fifth Circuit. So that was one where they kind of leapt in. And I think that there is parallel in the impoundment cases. So we saw that in the deportation cases where the Supreme Court jumped in and made ridiculous new law on the shadow docket in this 4-paragraph order where they were like, no, it's got to be habeas cases, right? And then in the Impoundment Act cases where the courts, with trial judges, were saying, give all of these grantees their money. This is ridiculous. Cough it up the way Judge Lamberth did it. They jumped in. And it's funny. The reason it isn't really a Tucker Act claim is that you've seen a bunch of these other cases come forward. I think it was the global health awareness, the USAID grantees, right? Judge Amir Ali ordered the State Department to release those funds. And the first time it went up to the Supreme Court didn't say, well, obviously this is Tucker Act, Judge Ali, you don't have jurisdiction. What they said was, no, you have to think about it or something. You can't make them do it. They didn't come up with this Tucker Act justification to kind of screw with these cases until much later on. They didn't come up with it until last week when they said, oh, well, Department of Education doesn't have to disperse these grants to the states, these education grants, because of, Tucker Act. And then it was like a 4-paragraph sort of tossed off order. But this one has a potential to be really devastating. It's going to screw the whole thing up, because if the Trump administration could just impound and force people to go to the Court of Federal Claims, then, like we said, then the budget doesn't matter.
Yeah, I think that's exactly right. And I would add that, the lower courts were able to salvage part of what the Supreme Court did, right? The Supreme Court said, hey, look, we're going to give detainees due process. It just has to be as habeas actions. And the trial court judges, all but one, said, yeah, you know what? We're going to let them bring class action habeas actions. Well, maybe a little sketchy on that, maybe. But now we have 6 cases instead of 300 or 3,000 or what have you. And here, if these have to go forward, if these impoundment cases have to go forward as Tucker Act claims, I don't see how they're going to be able to they're not going to be able to certify class. Right? You're going to have 10,000.
Right. And that's clearly what the administration wants to do. And so, to bring this kind of all back together, we talked about Humphrey's executor and the hiring cases. Mm-hmm. There have been at least one amicus brief, and I think multiple, that kind of tried to walk the Supreme Court through the logical endpoint of what they're doing here by blowing up all of the protections for agency heads, which is that Trump is going to fire Jerome Powell, the chairman of the Federal Reserve, and it's going to totally screw the economy, right? Because that will cause total panic. And who's he going to stick in there? He's at Caligula. He's going to make his horse chairman of the Federal Reserve,
Peter Navarro,
or Don Jr. or whoever, whatever. But it will be so destabilizing that litigants or certainly amici are saying, "Hey, Chief Justice Roberts and Amy Coney Barrett, because you're the only 2 reasonable." Ish people on the conservative wing, if you let Trump do this, based on your back of the napkin math, then it's going to totally blow up in your face and you're going to be the one to get blamed. And with the Impoundment Act cases, in some sense, it's worse, right? If as you said, then there's functionally no remedy, and the Congress doesn't have any more power. Congress has no power over the budget, which is what Project 2025 wanted, but it isn't what anybody else wanted.
Yeah, I think that's right. So, we have talked about the Department of Education versus California decision. And I think really the question is the Supreme Court going to be willing to walk back that language? The D.C. Circuit may hear this en banc, but ultimately that's where this is going to wind up. And that's what we're going to have to watch.
Yeah. All right. That is going to do it for us today. Thank you guys so very much. If you enjoyed the show, we would so appreciate you leaving us a nice comment and a 5-star review on your platform of choice. And we will be back on Thursday with written content and Friday with another show. See you guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.